Greetings. Thank you very much for coming. So now we're moving into the last phase of the lecture series. We started, you remember, with where we are now. We started with the background of animal welfare law. We went to the history and the ideas behind it and the science, some of the science underpinning it. And we got to a stage of saying, okay, here's what the law looks like now. Here's the sort of rights, or if you like, thin rights that animals have. Here's the welfare protection. And we looked primarily at the UK, but remember we also looked at other countries. So that left us with the question, well, is this feasible? Does welfare go far enough? Do the present laws go far enough? Or could we go further? Could we actually give animals thick rights and not just thin rights? So then we looked at the jurisprudence, we looked at the legal philosophy behind it and the ideas behind animals having rights, whether it's something that can be done. And that led us to the stage of basically saying, yes, this is a theoretically practical thing to do. We could understand the rationale behind it. Then we looked at human rights, because that would be an obvious analogous situation, an analogous set of legal principles that could either be drawn on or could be the format, or indeed could themselves be the basis for animal rights. So we looked at those and the extent to which those are relevant. And now we're coming back, if you like, onto pure animal rights themselves. In other words, this final section is, where are we now? What are people actually doing with animals and claiming rights for them? And so over the next few weeks, what we're going to be doing is looking at the case law in relation to animal rights and the argument whether they have rights. But then we're also going to be looking at what animal rights might look like. In other words, in a reformed legal situation, legal environment, what sort of rights might exist for animals, how might that work, and what are the implications. So we're starting now with people making actual efforts to protect, to see whether animals can have some sort of rights, and not just the thin rights from welfare. Now, one of the big problems which we have with animal rights is this idea of standing, of locus standi, which you've probably already come across. And this is the notion that you have to have standing in court in order for your case to be heard. Are you an eligible plaintiff? Do you have some interest, an appropriate level of interest, to bring the case? And in general, animals are not regarded as having interest in themselves, therefore it's a matter of finding people to bring those actions. And then you get all sorts of cases where people are bringing a case because they were working in a slaughterhouse and were upset by what they saw, or had some other link with the case. But basically the lack of standing has often meant that cases are simply not heard by the court at all. Now, the point about habeas corpus is that because it's about bringing someone who's probably in captivity and unlawfully held, and about releasing them, the standing rules simply don't apply. They're felt to be inappropriate because, almost by definition, someone's bringing a case on behalf of somebody else and doesn't necessarily have a direct connection with them. So the great thing about habeas corpus is it overcomes this first hurdle. And that's why it's become a litigation route of choice. And it's been brought in a number of countries. The Stephen Wise and the Non-Human Rights Project has brought a number of cases, but we've also seen them in other countries. However, sorry if this is a bit of a spoiler, generally it hasn't worked. Generally, habeas corpus cases haven't got very far. They've been heard by the court, but they have usually been rejected. What we're going to do tonight is really look at the cases, look at some of the cases, and see how the courts approach them, because there was quite interesting arguments used by the courts. Whether you find the court's views unsympathetic or whether you find them quite rational, I think is a matter of judgment for you. One can see in the judgments the courts really, in some cases, often sort of wrestling with the conundrum. And in some cases, we'll see some of the judgments are really being quite positive about the animals for whom the petitions are being brought. Really quite sympathetic, and yet also concerned about their role as judges and the role of the courts. So, interesting cases, and as I say, something of a conundrum. So, let's start with Tommy, a chimpanzee in the New York Zoo. The cases were merged with another case, Kiko, a little later on. So, brought in 2013, rejected. And the court goes straight in, a novel question over whether a chimpanzee is a person, because habeas corpus is about persons. So the court feel the first question they have to ask is the chimpanzee a person? And they then do what courts do, which is go into the present, go into the history. Not surprisingly, animals have never been considered persons, nor explicitly considered as persons. So a very straightforward bit of common law legal analysis. Well, have they been treated as persons before? Can we find precedent for it? And the answer was no. Historically connected with the imposition of societal obligations and duties. Now, this is where the court really decided to go into the jurisprudence. In other words, what does it take to be a person? What's it about? What's liberty? What is the liberty that is being protected by the writ of habeas corpus? And what they're saying is it's historically been connected with the imposition of obligations and duties. So the rights you get, the liberty which a habeas corpus could give you, is there because you had duties. The reciprocity between rights and responsibilities, that's the social contract that one has made. That's why you're entitled to a habeas corpus protection, because of the duties that you've undertaken to society. That's the contract you've made with them, the correlation of rights and duties. And it said legal personhood consistently been defined in terms of both rights and duties. Now, having set out that stand, having set out that as the grounds for having the rights, that you've had, that you accept the duties, and set it out as a contract, and therefore you cannot have the benefits of a contract without accepting the burdens, of course they then chose to apply that analysis to Tommy. Chimpanzees cannot bear any legal duties. They can't have societal responsibilities or be held legally accountable. Now, as we've seen from some of the earlier lectures, and you may have come across in your reading, that's not entirely true. There's all sorts of primatology evidence, analysis, that actually chimpanzees and other primates do take responsibilities. They do have societal responsibilities. Part of living in a social group creates responsibilities to your peers and so on. So there's actually quite a lot of evidence that just living in a group creates societal responsibilities. So what the court was meaning was the sort of societal responsibilities that we understand. Not do they have, can they be have social rules and social guidelines they have to comply with? Yes, they do. Do they have the sort that we understand, the sort of structure we understand? And they said no. So, again, you can see the inexorable logic here. And the inexorable logic is the sort of legal duties we mean, or the court means, they clearly don't have. And whether that's something like, not crossing on a red light, or paying your taxes, or complying with not defaming anybody, or whatever, it doesn't matter. They just mean all the sort of rights that we think of that human beings have, chimpanzees don't. They weren't interested in looking and saying, can they bear them in principle? They were saying, can they bear the sort of responsibilities we think about? Which, of course, then produces the clinching outcome. It is this incapability to bear any legal responsibilities that renders it inappropriate to confer the legal rights. So the logic, if you buy into the logic at the beginning, is very compelling. Habeas corpus is a right which you get as part of your social contract, and your duty as the other side of that contract is your duty towards society, your legal duties. And so the implication is you get the rights because you bear the duties. Chimpanzees cannot bear the duties, therefore it's inappropriate to have the rights. That's their logic. The fundamental right to liberty protected by the writ of habeas corpus, that had been afforded to human beings. So once they were down that logical path, it became very difficult for anything else to happen. However, it was appealed, and along this point joined with Kiko, and the court denied leave to appeal. But one of the judges gave his opinion. What's happening now is he's coming up with a different logic. He's parking all of that and saying, well, hang on. It's based on nothing more than the premise that a chimpanzee is not a member of the human species. In other words, he's saying, yeah, the inexorable logic of the social contract is all very well, but actually, this is just saying they're a chimpanzee, Tom is a chimpanzee, not a human. So the things that humans have, a chimpanzee cannot have. That's all this is about. So he's breaking with the logic. He's refusing to go down the logical path of the court. He's refusing to go down that at all and just say, no, this is a completely different thing. So the better approach, he's saying, let's turn another way. The better approach is not to ask whether it fits the definition of a person, but whether he or she has the right to liberty protected by habeas corpus. So don't start talking about them being humans. Don't start talking about rights and duties. Just say, does this person, this non-human animal, have the right to liberty? That's the question you should be asking. And it's a much simpler one. And it's one that hasn't got all this baggage of social contract. Now, he posed the question, does he or she have the right to liberty? Now, why should you have the right to liberty? What would give you that right? Why should a non-human animal, why should a human have that right or expect that right? Why should a table not? And now he comes in for his key argument. Does an intelligent, non-human animal who thinks and plans and appreciates life as human beings do have the right to the protection of the law against arbitrary cruelties and enforced detentions visited on him or her? So this is his point, which is, and the implication is, of course, yes. But what he's saying is, when should someone have the right to liberty? Well, they should have that right when they understand that it's been taken away. When they understand that they are the victim of arbitrary cruelties. This is someone who's thinking and planning and appreciating life. That's why they should be considered for habeas corpus, because they have that entitlement. This is not a definitional question, but a deep dilemma of ethics and policy. How should we view animals? Because if you go down the social contract, animals are always going to be unable to succeed. If you go down the route that says, hang on, what's all this for? Why do we have habeas corpus? Well, it's the idea of unfair treatment. It's the idea of unfair control or detention. And when does that matter? It matters when the person who is being detained understands it and understands what's happening to them. And then he put the other side. And he's saying, well, okay, you may not agree with that. But if you don't agree, then you're regarding the chimpanzee as entirely lacking independent worth. You're saying it doesn't matter what the animal thinks. It doesn't matter what they feel. It doesn't matter whether they have plans, whether they enjoy life. You're saying they entirely lack independent worth. They're a mere resource, a thing, the value of which consists exclusively in its usefulness to others. So he's saying, is that what we're saying? Is that how we're describing them? Because that's the logic of rejecting their humanity is the wrong word, their personhood, the fact they're alive and thinking and are aware. And he's saying, no, we shouldn't be thinking about the chimpanzee in this way. We should consider whether a chimpanzee is an animal, is an individual with inherent value who has the right to be treated with respect. So he's coming at it from the other side. He's saying, let's not talk about persons and social contracts and all this stuff. Let's just talk about respect. When should someone be treated with respect? What criteria should you have for that? If your criteria is human, well, then you're going off a different path. But if your criterion is the idea of awareness and thinking and so on, that you're an individual with inherent value, then we can go down that path. And then he said, look, by the way, this isn't bringing humans down. This is, yes, there's a gap between human and non-human species. But we're not talking about bringing humans down. All human beings possess intrinsic dignity and value. In elevating our species, we should not lower the status of other highly intelligent species. So he's saying, one, moving up the status of the chimpanzee doesn't mean we're depressing our own species. And when we improve the lot of our own species, it doesn't mean we should be lowering that for others. In other words, the connection is not a lockstep. That we can actually do both. The issue whether a non-human animal has a fundamental right to liberty is profound and far-reaching. So, he's saying, yeah, I understand this is serious stuff. It speaks to our relationship with all the life around us. So he's really facing up to this issue that are we being stuck in this human definition, straitjacket that excludes everything else, or are we going to think about animals as persons and having a mind of their own and thoughts and emotions? And he's saying, he's also looking to the future and saying, ultimately we'll not be able to ignore it. Yes, we may not be able to argue that a chimpanzee is a person. There's no doubt that it's not merely a thing. So he's now looking forward and saying, this is about our relationship with life around us. So it seems to me a very interesting case. He's saying, he's part of the court that rejected the appeal, but he's saying, let's come at this another way. Let's just think about whether a person is aware of its situation, is aware of treatment being meted out, is aware of the detention. Isn't that the basis that we should come at? Shouldn't we be thinking about non-human animals in terms of themselves, and rather than thinking about them as simply not human? Some more chimpanzees, Hercules and Leo, State University. Again, non-human rights project. Again, habeas corpus, and again, rejected. Now, these cases were coming in the slipstream of Tommy and Kiko. And they said, yeah, the concept of legal personhood has evolved significantly since the inception of the United States. So they're understanding that legal personhood has moved forward. Not very long ago, only Caucasian male property-owning citizens were entitled to full legal rights. African-American slaves were bought, sold, and otherwise treated as property with few, if any, rights. So they're saying, yes, we We do understand there's an evolution in these things. We understand that this concept is not fixed. And even in the last 200, 250 years, it's moved significantly. And yes, we recognize that going back that period, a significant portion of the population who were treated very, very badly and were simply property, were bought and sold. So we understand that personhood can change. We also understand that there's a binary approach at the moment in the law. It's an all or nothing. Persons have rights and duties, things do not. Animals are property under the law. They are accorded no legal rights. So this is this binary idea that you're property, you have no rights. This is the binary approach that they're talking about. And saying, yes, we understand this. And their only right, as we said in Raphael's talk, the lectures, they have thin rights. The right to be free from physical abuse and other mistreatment. That's all they have. But again, you see the words, animals including chimpanzees and other highly intelligent mammals. So again, they're recognizing this conflict. But they were bound by Tommy and Kiko. And they felt they had no discretion. They also made another point, which is more constitutional and worth bearing in mind. The issue of a chimpanzee's right to invoke the writ of habeas corpus is best decided, if not by the legislature, then by the Court of Appeals, given its role in setting policy. In other words, it's saying, where should this be decided? Who should be making this sort of momentous decision? Is it really for us? Well, really, it should be the legislature. This is a legislative thing. Now, obviously, this is a US case, and therefore the relationship between the legislature, particularly the Supreme Court in the judiciary, and the legislature is different from the UK, and clearly there's been a number of areas where the US Supreme Court has made significant policy decisions. But here's the court saying, really, it shouldn't be us. Are they just being constitutionally realistic, or are they passing the buck? Well, not entirely sure. Probably some of both. Again, then, they reflect similarities between chimpanzees and humans, inspire the empathy felt for a beloved pet. Again, these aren't things. Efforts to extend legal rights to chimpanzees are understandable. Yes, we get it. We get the issue that you're trying to do. And someday they may even succeed. Courts are slow to embrace change. Well, it really depends. If you think the court was right previously saying, well, this is a legislature thing, or this is a higher court thing, then you can let them off the hook. Or you can say, well, this is just Weasley here. They're just saying, oh, that's a really good idea, that's excellent, and I can see that happening. But, things are very slow, and things don't move that quickly, and, it's really not for us. But again, of course, the question is, why? Why isn't it for you? You're the court. You've got the power to do it. Why are you not making that decision? Is your constitutional role and status just a convenient get-out? Or should we regard it as a genuinely accurate statement that this is really not for them and suitable for somewhere else? But the idea that someone else will do it, someone else will pick it up, people in the future will change these things. It's almost a sort of comfort food, isn't it? It's sort of saying, well, it's all right, someone else will do it. It's all right, someone in the future will do it. And yes, we do understand, but we're not going to do anything. Whereas the other argument says, hang on, this is your job. You're the place where people bring petitions for writs of habeas corpus. Get on with your job. If you think you don't want to grant it, fine, don't grant it. But don't pretend that it's somebody else's job. Don't pretend that people in the future are doing it. So somehow, if it was left to you, you'd be quite happy. Again, you need to decide where you think they're figuring in all this. Cecilia. Again, habeas corpus. In this case, as with the other cases, the petition was essentially to move them from a zoo to a sanctuary. Saskia Stuckey wrote this. 3rd of November 2016, an Argentinian judge, kind of given it away with the heading, I'm afraid, but would have been better without the heading. An Argentinian judge granted habeas corpus relief to Cecilia, a person held captive in a small cage, nothing out of the ordinary, except the fact that Cecilia is not a battered woman or an abused girl, but a chimpanzee kept at Mendoza Zoo. I probably would have better bite without the heading. So it's interesting the way that Saskia's written this, and this was the start of her short blog article, if you have a chance to read it, presenting it in a very ordinary way and saying, yeah, here's someone who's held captive in a small cage. Of course you're going to give her, of course you're going to issue a writ. Of course you're going to order her to be released. It would be absurd not to. Apart from the fact she's not a battered woman or an abused girl. So I think it's a very compelling way of putting it. It's only when you see that it's an animal, not a human, that perhaps any reconsideration is valid. Yeah, so the court had quite a range of arguments in this case. So it's not just a matter of individual rights, it's about collective good, it's about how we think of ourselves. It's about society, it's about a constitutional right to a healthy and balanced environment. And you really have a healthy and balanced environment while we're doing things like this to persons within the country. And classifying animals as things is just wrong, just the wrong thing to do. It may have historical accuracy, but the court said, no, it's just not right. Again, this whole elevating animals, reducing the status of humans. No, we're not saying they're the same. This is a different story, a different narrative. We're not saying that sentient beings, animals, are the same as human beings. No, they're different. They're entitled to be thought of differently, entitled to be, for the court to reflect on them differently. What we are recognising is that primates are non-human legal persons and possess fundamental rights. So in other words, going straight for the heart and saying, yeah, they are non-human legal persons and they have rights. Because of their nature, because they're sentient, because they're alive, because they're part of our social fabric, because they're part of the environment. Anyway, so Chucho, in this case a bear in Colombia, habeas corpus again to be released to a sanctuary. The writ was granted, and a number of arguments again were given. First of all, this idea of the legal framework, subjects of rights, this idea of legal persons, all sorts of legal persons, human people, associations, commercial societies. In other words, what he's saying is the law has already made lots of things legal persons. So that ship has already sailed. If we were saying that humans were the only legal persons, or you had to be human to be a legal person, then you could follow the logic. But they're saying, well, no, we've already broken that one. So what precludes us from acknowledging the other truly living, sentient, animated realities with juridical person? In other words, if you can have some public association as a person, which is absurd, why can't you have a real person? An animal, non-human animal person as a person. It's almost emphasizing the distortion of the narrative, that we can recognize someone as a person who's clearly not a person, but we're calling it such, because it's convenient, because we want to do it. So what stops us actually granting personhood to other categories, going beyond the traditional conception of nature as an object that humans have a duty to preserve? In other words, going beyond the way we traditionally view them as an object over whom we have some responsibilities. Lavery, the Tommy case, we must relax the principle that holds a thing is reciprocally bound to comply with a set of duties. And again, Raphael covered these in his lectures. So he's just saying, no, this is just not a sound basis for the argument. This is a straitjacket which was introduced, and we must get away from it. We must accept they're the subject of rights despite not being reciprocally constrained. And as you recall from Raphael's lectures, that's social contract idea is one approach, but certainly not the only one. But he also said, well, okay, let's talk about rights, but they need appropriate rights. Animals need appropriate rights. Not rights in every respect analogous to those that human beings enjoy. In other words, we're not just wholeheartedly copying and pasting human rights to animals, nor must they have the same prerogatives and guarantees that humans possess. Again, we're not just saying it's a one-for-one, but rather what sort of rights they should have, rather those which correspond to or are fitting to or suit their species, rank and group. In other words, once we've established that animals should and can have rights, then we need to think about, well, what are the appropriate ones for them to have? And of course, it's not difficult to imagine what they would be. Appropriate to their life. So again, pushing back the criticisms of right, go, well, this is ridiculous. You're granting animals a lot of human rights, which is absurd for their needs. Decision was overturned on the grounds it's linked to the defence of freedom of human beings. So habeas corpus is only for people, not animals. It's an inappropriate mechanism. Some elephants, Beulah, Minnie and Karen. Again, this was a travelling circus in Connecticut, Comerford Zoo. There had been a number of complaints and welfare complaints made against the zoo over the years about the treatment of the animals. And so this was another way of trying to have them moved to a sanctuary. One of the arguments that the Non-Human Rights Project has often made, and I think probably sensibly, is to say, look, this is just habeas corpus. This is all we're doing. Let's just get this particular right, the particular writ granted for this particular animal in this situation to move to this sanctuary. And let's not go down the path. Let's not talk about slippery slopes. It's very easy to object to something which is good in its, which is sensible in itself, because it might lead to a slippery slope. It's a terribly weak argument. It's a terribly weak concept. And because of that, and of course it's also hypothetical. Does it lead to a slippery slope, or is it just, does it stand alone? And the Non-Human Rights Project has usually emphasised that these things stand alone. The court wasn't having much of this. They said it's more than what the petitioner purports it to be. This isn't just about recognising elephants as persons or habeas corpus. It would require us to upend this state's legal system to allow highly intelligent, if not all, non-human animals the right to bring suit in a court of law. Now, of course, the temptation at that point is to go, hurrah! But I don't think they meant it that way. They meant, no, we don't want to do that. It would upend this state's legal system if we started doing that. Heaven knows where it would lead to. So they're saying, yeah, if we did this, then other intelligent animals could bring cases, or indeed all non-human animals could bring these cases. And that's not what the court was wanting to do. well, we decline to make such sweeping pronouncements when there exists so little authority for doing so. And again, we went back into jurisprudence, and there's no indication that habeas corpus relief was ever intended to apply to a non-human animal, irrespective of its purported autonomous characteristics. This is like the party that I may or may not have attended that may or may not have been a party sort of defence. So they're now backing away even from whether these animals have autonomous characteristics. And again, they went back to Lavery. An elephant or any human being is incapable of bearing social duties and social responsibilities. So the point is that this social contract becomes the line of defence. And it's quite a good line of defence if you buy into the social contract as the only way of getting rights. Ascription of rights has historically been connected with the imposition of societal obligations. In other words, that's the hurdle you have to cross. That's the hurdle you have to jump. And it's saying, yeah, it's a social contract. And you can imagine the sigh of relief when they were able to write this. We found no place in our general statutes where the term person has ever been defined as a non-human animal. Thank heavens, we can all go home now. There's no precedent for it. So we have this amazingly flexible common law device of habeas corpus that's designed to cut through and challenge the state at a fundamental level and say, release this person, you have no right to keep them. Putting huge power in an individual case in the hands of the court, and the court are going, well, I'm sorry, I mean, he's purported sentient. Can't find any precedent for that. This is supposed to be a court designed to protect us, and yet they're acting as though they're administering parking fines. And yes, there are profound implications for a court to conclude that an elephant or any non-human animal is entitled to assert a claim in a court of law. We have little difficulty concluding that the elephants do not have standing to file the petition. They have no legally protected interest that can possibly be adversely affected. Wonderful piece of language. I read it over and again. I'm not entirely sure what it means. I think what it means is it's not they don't have an interest that needs protecting. It's they have no legally protected interest. In other words, we're not going to recognise they have a legally protected interest, therefore there's nothing to adversely affect. So it's a curious bit of logic, but I think that's what it means. If someone can help me with that, I'd be obliged. But I think they mean that it doesn't have any legally protected, that the law doesn't protect their interest, therefore by definition, if you don't have an interest, it cannot be adversely affected. Happy. Now, the interesting thing about Happy is that it's still going. Unfortunately, so is she. Bronx Zoo lives on her own, her death after her companion died, been on her own some years, and again, habeas corpus. Again, they felt they were bound by Lavery, the Tommy decision. However, so in this case, again, as we saw before, really quite a sort of open approach, or at least open reflections by the court, extremely sympathetic to Happy's plight. So we've got away from this purported animal, purported sentience. Happy's an extraordinary animal. Complex cognitive abilities akin to human beings, more than just a thing, an intelligent, autonomous being who should be treated with respect and dignity, and who may be entitled to liberty. Let's just settle, should be treated with respect and dignity. And you then wait, and it would lead to a labyrinth of questions that common law processes are ill-equipped to answer. to have a species other than Homo sapiens as persons really would create a lot of problem. However, the case is still under appeal. If you look on the reading list, you'll find a talk at our conference in the autumn about it, and also a copy of the Amici Curiae that was submitted by a number of English academics, including Raphael and myself. Although I think it was Dr. Joe Wills who did the bulk of the work. And essentially, he takes you through some of these arguments. Because obviously what's happening is all these cases are coming in behind Lavery. They're coming in behind Tommy and Kiko. So you need, to challenge these, you have to unpack Tommy and Kiko. So, yeah, the one to follow is Happy, to see where this is going to go, whether the New York court will decide in favour. So, is it the slippery slope? Yes, I'm sure it is. In this case, it probably is a slippery slope. Because if it works for Happy, then of course legal precedent will take over and say, okay, so what sort of animals can be protected, what sort of circumstances they need to be in, and what sort of improvement can be expected. In principle, it could go from zoos to farmed animals and to laboratory animals. It's very hard to imagine precedent, the nature of precedent itself, like cases being treated alike, to keep lonely animals on their own in a zoo. And bear in mind, I think there was no particular argument in the case of Happy, unlike Minnie and Beulah, there was no particular argument that she was being badly treated. I don't think there was any issue. Is that right, Raphael? There was no, that's right. She had veterinary help support. She had reasonable conditions and so on. So this wasn't a sort of sort of welfare question. This was the idea that she was a lonely, was a animal that needed companionship and was lonely. That's the basis. So it may well go further. Obviously, we've touched on some of these, the arguments for and against. Yes, common law should be flexible. The habeas corpus is designed as a sort of, something of a last chance for an individual to get redress where the state has either failed or you can't break through the process of the state. It is the chance for the judiciary, if you like, to re-evaluate or re-examine what the executive branch has done. So they have a very clear role, and within that, over hundreds and hundreds of years, the opportunity to, if you like, deal with injustice. So on the one hand, there's a lot that could be said in support of courts deciding to grant it. On the other hand, as we've seen from some of these cases, yes, there's a lack of precedent. You go back, persons have always been human persons, and there's no evidence of animals being regarded thus. Yes, and we said the potentially enormous implications. Now, whether those implications are intrinsically good or bad is a different thing. It is possible, of course, that if a court, say in Happy or in another case, did grant habeas corpus, then perhaps precedent would then start being refined. What sort of situations will it apply to? And what I think we might see is that the line is moved, but not destroyed. The line between human and non-human at the moment, which is where it is at the moment, would move. Now, where would it get moved to? We don't know. It doesn't have to go to farmlands. It could be, about introducing companionship and so on, and emotional state as part of things to take into account. Or, of course, it could go much deeper and say, well, the animal Happy was lawfully kept in the New York Zoo, and yet habeas corpus is being granted. In other words, that is habeas corpus even appropriate where the detention is arguably completely lawful. And then, of course, the final point, are the courts just the wrong place to do this? And I think that, again, as I said earlier on, is something of a constitutional question. Is this something, is this where the courts should be going? Or actually, is it a much bigger question which should be decided either in a much, much higher court or indeed in a different place altogether? A couple of sort of minor concerns. Are we in danger of moving the line, but only a little bit? So, one of the elements was the idea of sentience, the idea of similarity of DNA, almost identical DNA, as though these were the sort of criteria that should be connected with rights. Now, is that a good idea? Well, you may say yes. We need to, that if the law is going to evolve, it needs to deal with cases for which there's more sympathy or more scientific basis. Or you end up saying, all that's actually happened is that a favoured group has been granted rights, but actually animals where the DNA differences are much greater aren't going to get protected. So you may feel that one's moved the line, but only a little bit. You've moved it from sort of perhaps great apes and humans and so on, and elephants on one side to other animals on the other. So it's not clear, even if they did grant it, how far other cases would go. And there we go. Not sure about the 2 kisses. That may be a mistake. Right. Thank you very much. Raphael, which button do I press?
Just escape, I think. Yes, that should probably stop the recording, otherwise you're just going to...
Shut down?
Or maybe just, close PowerPoint and see if they're still recording, but maybe in the background behind this. I hope it was there. It's gone. That's a bit odd. There it stopped.